If you thought Sean Diddy Combs was just battling one lawsuit at a time, oh honey, you severely underestimated this man's stamina. Because now, he's pulling a full reverse card. We're talking a $100 million defamation suit that basically screams, "You dragged my name, I'm dragging you to court, in style." And the reason the judge laughed out loud during the preliminary hearing? Yeah, you'll want to hear this. So here's the scene. It's mid-2025. Diddy's already knee-deep in multiple legal swamps, past assault allegations, a couple of civil claims, and an FBI investigation whisper campaign that's been floating around like the worst party guest who just won't leave. But instead of hiding behind tinted limo windows, he's suiting up and firing back with a 9-figure lawsuit against the woman who accused him of a violent assault, a claim he calls completely fabricated. And trust me, the filing is less dry legal doc and more Shakespearean clapback. All right, let's break this down. Legal tea first, drama second. So here's the headline grab. Diddy's suing for defamation, demanding $100 million in damages. Why that number? Because in celebrity legal land, it's not just about compensation. It's about sending a message. And this message is basically, I am not the scandal you think I am. The lawsuit was filed in the New York Supreme Court. And quick legal note, in New York, Supreme Court is actually the trial court, not the highest court. Why file there? Venue strategy. New York is where a lot of Diddy's business interests operate. It's where the alleged harm to his reputation hit the hardest. And, bonus, the state has a track record of celebrity-friendly defamation verdicts. The complaint accuses the defendant, let's call her Jane for now, of knowingly fabricating assault claims, then feeding them to media outlets for maximum damage. Legal translation. Defamation in most states, including New York, has 4 elements. A false statement about the plaintiff, publication of that statement to a third party, fault amounting to negligence, or, for public figures, actual malice, and damages, meaning the statement caused reputational or economic harm. Now here's the catch. Because Diddy is a public figure, the bar is way higher. Under the famous New York Times versus Sullivan case, he has to prove actual malice. Not malice as in personal hatred, but that Jane knew the statement was false or acted with reckless disregard for whether it was true. In other words, you can't win this just because someone was sloppy. You have to prove they knew they were lying or didn't care if they were. And the complaint goes even more pointed. It calls the statements defamation per se, meaning they're so inherently damaging, accusations of serious crimes like assault, that Diddy doesn't even have to prove specific damages to his reputation. The law just assumes harm. But of course, he's still bringing receipts to show exactly how much it cost him, which brings us to that big, shiny $100 million figure. It's not random. The amended complaint points to lost endorsement deals worth at least $20 million, a canceled joint venture with a major beverage brand valued at $30 million, streaming distribution talks for a biographical documentary that allegedly died on the vine after the allegations hit. Add to that the projected loss of future opportunities, appearances, speaking gigs, licensing, and his legal team is basically saying, this wasn't a bad week for him. This was a corporate earthquake. And in the court of celebrity image, lost opportunities equals lost brand power. But if you think this is just about cleaning his name, wait until you see the scorched earth PR move hiding in the fine print. The original suit was filed months ago for a smaller amount. But in the amended complaint, Diddy's lawyers go full cinematic mode. And quick legal note, an amended complaint isn't just a rewrite for style points. Under Rule 15 of the Federal Rules of Civil Procedure, or its New York equivalent, CPLR Section 3025, you can amend to add new facts, adjust the claims, add or remove defendants, and even increase damages. The rule says courts should freely give leave when justice so requires, which in human speak means if you've got fresh ammo, the judge will probably let you reload. They've now included detailed timeline receipts, travel logs, security footage, timestamps, text message screenshots. These aren't just flexes for the media. In court, evidence like this is gold because travel logs and business records fall under recognized hearsay exceptions, making them more likely to be admissible. Sworn affidavits from people allegedly present the night of the supposed incident. Affidavits lock in testimony under oath before trial, meaning if a witness later tries to forget something on the stand, the affidavit can be used to impeach them. And my personal favorite, a side-by-side media leak map, tracking which outlets got which details and when. That's basically a breadcrumb trail for showing intentional coordination. Why this matters legally. Defamation cases can live or die on the issue of actual malice, and a leak map helps establish intent. If they can show the accuser or her associates strategically fed false claims to certain outlets at certain times, it looks less like, "I told my friend and it got out," and more like a deliberate smear campaign. And then there's the cherry on top. Diddy's lawyers claim they can prove financial incentives behind the story, as in certain parties allegedly got paid to talk. That's where things creep into possible criminal territory. Why? Because if money changed hands to make false statements, prosecutors could start sniffing around for charges like witness tampering, if the payments were tied to influencing testimony, obstruction of justice, if the intent was to derail any official proceeding, and even wire fraud if the scheme used interstate communications. And trust me, emails, texts, and wire transfers qualify. And don't underestimate the psychological chess here. By putting all this in the public amended complaint instead of just holding it for trial, Diddy's team is sending a message. We have the receipts, and we're not afraid to play them in the press as well as in court. But hold that thought, because there's another player quietly lurking in the background, and they might just be the puppet master of this whole circus. Here's where it gets spicy. Buried in paragraph 64 of the amended complaint, there's a mention of a third-party media consultant. No name given. But insiders whisper it's someone with a track record for flipping celebrity crises into full-on viral firestorms. Think Olivia Pope if she billed by the tweet, but working for the villain of the story. This mysterious consultant allegedly facilitated interviews, curated sound bites, and even advised on narrative framing for Jane. Translation, they didn't just help her tell the story, they helped her sell it. Now, legally speaking, that's where the web starts to tangle. If a consultant knowingly helps push false statements, they could face liability under aiding and abetting defamation. That's when someone assists in committing the tort, even if they didn't write the false words themselves. And then there's the concept of agency. No, not like a talent agency, but the legal idea that if someone is acting on your behalf with your authority, you can be held responsible for what they do. If Diddy's team can prove Jane was essentially the principal and the media rep her agent, both could be on the hook for the same defamatory statements. What would proving that look like? Subpoenas, and lots of them. Phone records to show call patterns before leaks dropped. Email chains tying the consultant to journalists. Payment records that might prove the rep was compensated in exchange for pushing the story. And here's the big twist. There's speculation this consultant was also the source for those FBI investigation whispers that started floating around in late 2024. If true, and if those whispers were knowingly false, it could escalate into a civil conspiracy claim, basically alleging that two or more people worked together to damage Diddy's reputation through unlawful means. Civil conspiracy isn't a standalone tort in many states, but it's a way to rope multiple players into the same liability net. If the consultant is named in a future amended filing, this could shift from a one-on-one legal duel into a sprawling multi-defendant litigation circus. And if the court connects this consultant's activities to any false information sent across state lines for financial gain, it could also trigger the attention of federal prosecutors under wire fraud statutes, turning what's now a civil case into a criminal subplot. But hold your gavel, because whether or not this mystery figure gets pulled into the fight, the next phase of this war will decide whether Diddy's legal strategy is genius or the most expensive cell phone in hip-hop history. In public, Diddy's been on the charm offensive, carefully curated appearances, heartfelt posts, business-as-usual vibes. But in court, it's a different animal. His legal team is going full surgical strike, dismantling the accusations line by line. The amended complaint even calls certain claims objectively impossible, based on verifiable location data. Now, here's where it gets fascinating. Defamation lawsuits open the door to discovery, the legal equivalent of pulling every skeleton out of the closet, shaking them, and then photocopying them for the jury. That means the defense can demand subpoenas for business records, contracts, and even security footage. Depositions, hours-long questioning under oath where every word is transcribed and can be used later in court. Interrogatories, written questions you must answer truthfully or face perjury charges. And the big one, electronic discovery, ESI, Think texts, emails, WhatsApp messages, encrypted chats, even deleted files if they can be forensically recovered. For celebrities, this is the danger zone. Even if the evidence disproves the assault claims, anything else unflattering that pops up could become public. One messy group chat and suddenly you're trending again. For the wrong reason. Enter the anti-slap wildcard. In states like California and New York, defendants in defamation cases can file an anti-slap motion, strategic lawsuit against public participation. If granted, it can shut the case down early if the speech was on a matter of public concern, and the plaintiff can't show they're likely to win. And here's the kicker. If Jane wins an anti-slap motion, Diddy could be ordered to pay her legal fees. So yes, suing is a flex, but it's also a gamble. Even if the anti-slap hurdle is cleared, there's another trap waiting. Summary judgment. Before trial, the defense can move for it, arguing that even with all the facts taken in the light most favorable to Diddy, there's still no legal basis to win. If the judge agrees, game over without a jury ever hearing the case. And that brings us to the moment that had everyone in the gallery chuckling. The reason the judge laughed. During a scheduling discussion, one of the defense attorneys suggested they'd need extra time to verify all of Mr. Combs's alleged charitable engagements. The judge looked up, smirked, and said, "Counsel, this is not a PR panel." The gallery lost it. The subtext? The court doesn't care about your Instagram philanthropy posts. It cares about your evidence. So, where does this leave us? Legally, we're staring down two possible endings, each with its own headline. If Diddy wins, he doesn't just get vindication. He gets a judgment, a permanent public court record that says, these statements were false. That's priceless in the PR world because it becomes the first thing brands, journalists, and search engines see when his name pops up. The money, that's where it gets interesting. In defamation, damages break down into compensatory damages to cover lost deals, canceled contracts, and measurable business harm. General damages for intangible harm like humiliation or loss of reputation. Punitive damages to punish the defendant if the court finds the conduct was especially malicious. Given the $100 million ask, the real number will likely depend on how the jury feels about the evidence. And in celebrity cases, juries have been known to go big if they think the plaintiff's life was turned into a circus for no good reason. If Diddy loses, it's a reputational gut punch. The defense will claim victory not just in court, but in the court of public opinion. Media will run the "where there's smoke" narrative, and the loss could embolden other accusers or inspire more lawsuits because it suggests Diddy's courtroom armor isn't bulletproof. Appeals? Absolutely. Defamation verdicts, especially high-dollar ones, are rarely the end of the road. If Diddy wins, Jane could appeal on the grounds of trial errors, evidentiary rulings, or improper jury instructions. If Diddy loses, his team could argue the judge wrongly applied the actual malice standard or misinterpreted the evidence. Appeals can stretch a case out for years, and in high-profile fights like this, that means the scandal stays in the news cycle far longer than the original headlines. And there's another ripple effect. Overlapping discovery. Anything unearthed in this lawsuit could be used, or subpoenaed, in his other legal battles. That means one false move here could open a door somewhere else. Statute of limitations also plays a role. If new parties, say that mystery media consultant, get named, Diddy's team has to move fast before the clock runs out on defamation claims, which in New York is just 1 year from publication of the statement. Bottom line, this isn't just a defamation case. It's a test of whether a celebrity can reclaim the narrative once it's been shredded in the digital age, and whether the courtroom is still a place for justice or just the most expensive stage in town. And if you think this is the last twist, please. In celebrity litigation, the final act is always the sequel.